Can I get my charges dropped or reduced? That's an excellent question. We get it all the time, and it is really a good question that's got a lot of permutations to it. So let's start from the beginning. Remember, when a charge is filed against you, you're still entitled to the presumption of innocence, and the government has to prove its case beyond a reasonable doubt. What typically happens in the criminal justice system, or even in the municipal courts, is that when charges are filed, we go through a process called discovery. Discovery sounds just like the word that it means. We discover what the case is about. And prosecutors and police are required under court rules to give us the police reports, and hopefully if your defense attorney is very good, they're going to get a number of other items in order to get an assessment of how good a case is or it isn't. I say this all the time to people. When you're calling a defense firm and you're asking, I hear these stories of, oh, I'll get you off, or I'll get the charge dismissed, or I'll get it reduced. With all due respect, we never make that promise at the Bianchi Law Group, because assessing a case is very much like when you have a lump, on your body and you go to the doctor and you say, am I gonna be okay? Any competent doctor is not going to say yes. They're going to send you for a biopsy. They're going to send you for blood work. They're going to send you for x-rays. And that discovery of information that the doctor gets, much like the discovery we get from the police and prosecutors, is going to be crucial in the doctor's assessment as to, one, is this something that's malignant? Is it benign? And depending on whatever the scenario is, how the treatment plan is going to go and what's going to be done. It's nothing different with regard to a defense lawyer. So we never make promises. I mean, yeah, after 30 years of experience in our team of former prosecutors, we have a good feel for things. But why this is so important to answer the question, will my charge be reduced or dismissed, is based upon the quality of the evidence that the prosecutor has to prove the case beyond a reasonable doubt. Listen, many times prosecutors and police overcharge cases. A lot of times people say, oh, criminal defense lawyers, all you're trying to do is get people off. And what we're doing is evaluating the case and to see if there's sufficient evidence to support the charges that have been, by the way, sufficient and competently admissible evidence that's sufficient to prove the case beyond a reasonable doubt. And there are many times where maybe the person did something, but not as significant or as high as what they were charged with. And then, of course, there are times where the client has done nothing. And there are times, by the way, where a client has done something, but they don't have the proof to prove it beyond a reasonable doubt. This takes the competencies of a very skilled, criminal defense lawyer, and that's why I only hire former prosecutors, because we used to prepare these cases. We know how prosecutors think. We know how they're supposed to be prepared, so we know how to evaluate the case from the defense side to see where there's any flaws in it. So why am I talking about this when the question is, can you get a charge reduced or dismissed? Well, in fact, many charges are reduced during the plea bargaining process. In the plea bargaining process, prosecutors and defense lawyers will make arguments. They'll make arguments about the facts, the sufficiency of the proofs, whether there's any legal issues. I mean, we're in courts all throughout the state with violations of the Fourth Amendment, unreasonable search and seizure, violations of the Sixth Amendment, not to incriminate yourself, violations of the Sixth Amendment, right to counsel, and many other legal motions that could be filed where the defense lawyers are saying the police did something that was inappropriate. Why do we file those motions? Because if they're successful, for example, I'm thinking of one right now that we have, and the judge suppresses a significant piece of evidence, the value of the prosecution's case gets lower. In other words, they're going to have a harder time proving that beyond the reasonable doubt to 12 people, and concurrently or commensurately, the plea bargaining process should start to adjust. We've had cases where they're asking for 15 years in state prison in the beginning of the case, and due to the work that's being done and the motions that are being filed, and as their case starts to fall apart, the offers go down to 10 years, and in 7 years, and in 5 years, and so on and so forth. So the plea bargaining process, even if a person is completely guilty, occurs. Okay, let's start with that. Completely guilty, the proofs are really good. Why does the prosecutor reduce a charge? Because prosecutors are overwhelmed with cases, and the courts, prosecutors, and defense attorneys understand that in most cases should be pled. Less cases go to trial than are pled, and the only way to incentivize a defendant to plead guilty is to obviously give them something less than they would be convicted for. Otherwise, any competent defense lawyer like us at the Bianchi Law Group are going to say, I'd rather go to trial and you take it from me as opposed to me handing it to you. And prosecutors understand this. So they incentivize the defendant by lowering the charge and lowering the plea offer from whatever the maximum sentence could be in a way to try to resolve the case. There are times when you ask about dismissal. Dismissals take time. And this is something we have to always try to educate our client on. Because there's an inertia that goes on once a charge has been filed and once you're in the court process. And the prosecutors opening the file for the first time believe that they have probable cause for the charges that are filed. If you have a defense to it, you have to not only build that defense, you have to make sure that it's communicated to the prosecutor. And if a prosecutor believes, certainly by their oath of office, which is not to seek convictions but to achieve justice, that's the oath of the prosecutor. And certainly I was one for a very, very long time as an assistant prosecutor and a county prosecutor. If I were to believe I either couldn't prove a case beyond a reasonable doubt, or certainly if somebody was innocent of the crime, nothing gave me any greater satisfaction as a prosecutor than dismissing that charge against them. And then there are certain instances in which it's a low-level crime and maybe the quote-unquote victim or the interest that the state has in pursuing that crime are no longer existent. In other words, a person doesn't want to proceed with the case, a victim doesn't want to testify, things of that nature. Maybe they've reconciled in the context of a domestic violence case, that the prosecutors will consider potentially a dismissal with that as well. So while dismissals are much more difficult to come by, certainly to answer the question directly, can you get a reduction? I would say in most cases from the original charges that are filed and the maximum sentences that could be imposed, prosecutors again are typically reducing charges and or the numbers that they're looking for in terms of either probation or jail time in order to settle the case. Hey, I hope that answers your question. It's a great question. We get asked this a lot at the Bianchi Law Group. And if you ever need any help or assistance with regard to this or anything else in the world of criminal law, domestic violence, or municipal court, our team of former prosecutors practice throughout the state of New Jersey. We'd be more than happy to help you out. Thanks for listening.